You read the title correctly, but I wasn't just copyright claimed by AI, I was claimed on behalf of AI. Now, I've had to deal with copyright issues before, but this scenario is particularly troubling and could prove to be another nail in the coffin for musicians and composers as we know them. Before we dive in, I'm just going to briefly explain the copyright system here on YouTube, as it's crucial to know the details of that to understand the full story. The subject of fair use and copyrighted content on YouTube is a bloody minefield at worst, and an awkward inconvenience at best, especially for a musician. YouTube allows content creators to use or reference other people's intellectual property without fear of demonetization or outright deletion if the work is deemed transformative. Transformative work, in YouTube's own words, means commentary, criticism, research, teaching, or news reporting. Basically, any creator using anyone else's material in these ways comes under the term fair use, and therefore does not necessarily constitute a copyright infringement. Great! I am first and foremost a music channel, so I expect to be claimed on my covers and busking vlogs because I'm fully aware that I'm performing copyrighted material. That's fine. These claims are made automatically by YouTube's Content ID system, which is really just a dumb robot that watches your video before it gets posted to see if you might have half-inched anyone else's work. It isn't perfect, and it has all the grasp of context of your average BuzzFeed contributor, so it is possible for me to appeal these if I felt I was within my right to use the material in the way that I did. The catch is that if the appeal fails, I get a strike on my channel, and 3 strikes, and I'm out. Scary stuff. Now, I'm not currently monetized, so getting claimed doesn't affect my income. What it does do, however, is stick adverts on my claimed videos, meaning that all of the money generated by these adverts goes straight to the copyright holder and YouTube themselves. I personally think that's a little bit cheeky, but I'm one man against a combined $200 billion corporate entity, so what can I do? Now, this is not a rant of YouTube's copyright system is broken, because I don't think it necessarily is. And I think it's fair if I play a song written by Foo Fighters that our lad Dave should get a little kickback from that. But why is being claimed on behalf of AI such a potentially contentious issue? Well, pull up a chair, grab yourself a drink, and let's see what weird and worrying things are occurring with AI this time. And more importantly, what distressing developments this could mean for the modern day musician. I recently uploaded a video entitled, "Does AI Mark the Death of Musicians?", wherein I reported that incredible leaps forward in technology now allows computers to create their own original art. Note the air quotes, they're pertinent to a topic of an upcoming upload. As part of my commentary on this looming threat to human creativity, I gave my reaction and critique on 3 such examples of music made by machines. If you've already watched that video, hey, welcome to episode 2 in my AI music series. It's good to see you again. If you haven't, please go and watch that one before this one, because it gives some much needed context to this script. No, it's cool, go ahead, I'll wait. Welcome back! Did you enjoy those examples? How about that last one, eh? That was so weird! So there I was. I reacted, I recorded, I edited and uploaded. Immediately, as I had half expected, and as you already know, Does AI Mark the Death of Musicians got copyright claimed. Okay, so what's the big deal? I reacted to something created by someone else, and all the YouTube Content ID system knows is that someone else's work is being featured in my own. These claims happen all the time on React and review channels, so this isn't anything special, right? I've ticked all the boxes to claim it's fair use, so just appeal it and move on, right? Right? Something didn't feel right, so I checked the details of the copyright issue with my video. I hadn't been claimed on behalf of the procedurally generated metal music, which is arguably an original with incredibly formulaic composition made by a human. Nor was I claimed on behalf of the estate of Rick Astley, even if what I had reacted to was a terrifying reimagining of a beloved classic. I was claimed on behalf of Ava, the artificial intelligence virtual artist. The fact that I had been claimed on behalf of a non-human entity didn't seem quite right, so I did a bit of research. According to the British Library, copyright in the UK must be held by someone who is, quote, either a British citizen or is domiciled or resident within the UK, or the work is first published in the UK or a country that signed up to the Berne Convention. Citizen, eh? Sounds like you might need to be a human to hold citizenship. In the United States, the Copyright Act, which by the way is more than 400 pages long, so thank God for Control F, protects works of authorship which only humans can create, so cannot be held by an animal, landscape, or machine. How can something that isn't human, can't have citizenship, and therefore no legal standing, possibly own the rights to anything? You can't copyright the sunset on behalf of the sun, or trademark the tide for the time of day. So do the creators of the AI own any of the art it may make? Strangely enough, there is a precedence for this kind of situation, and it comes in the form of a monkey. You may have seen this controversial photo taken by a celibate crested macaque named Naruto back in 2011. He had gotten his hands on the camera and, intentionally apparently, taken a photo of his smiley self. But despite this posing primate being both the photographer and subject of the image, it was agreed, over the course of many years and many disputes, that the beaming black ape could not and cannot legally own the image, even though he and only he had a direct part in creating it. The court ruled that the image was public domain. A monkey isn't human and therefore cannot hold copyright. This picture is for everyone. Interestingly though, the photograph wasn't taken by accident. The owner of the camera, David Slater, had intentionally sought to put this event into motion by gaining the trust of the McCorks and setting up his camera in a way to enable them to take the photo themselves. Slater fought long and hard for years to be granted the copyright of the image for himself, based on this fact. He was not successful. In 2014, the United States Copyright Office deemed that the work was created by a non-human and as such is not copyrightable. But it didn't end there! In a truly insane and indeed inane turn of events, 1 year later, PETA filed a lawsuit against Slater where he used the now public domain selfie in his book, claiming that the monkey should hold the copyright and hence be entitled to royalties. They failed, but then they appealed and then they tried again and it went on and on, but eventually they settled on Slater making some donations to a wildlife organisation and PETA stepped down. The courts had spoken! This picture is public domain. Neither Naruto, nor Slater, nor PETA own this picture. So where does this leave me? Ava is not a human. It's in her name. She is a virtual artist. She cannot hold copyright, and yet, here I am, being claimed by a machine. You could argue that her programmers hold the copyright to her music in the same way that a director owns the right to a feature film, despite the cameraman literally filming the thing. But here the rabbit hole becomes more of a warren. Ava is within her capabilities of composing almost indefinitely. Pop her on a never-ending live stream, constantly creating, you've got yourself an infinite money glitch with unlimited copyrighted material that no one can use without paying her. No, it must be in it. For legal reasons, she's in it. It's in it. Either way, this hardly seems fair. The programmers didn't write the music, the program did. Musicians don't pay royalties to their teachers for every song they write, nor does the client own the rights to a song they commission. But wild! I hear you cry. You've only cited British and United States legal precedents and copyright law. Is Ava even based in either of those countries? To which I would reply, excellent question, you clever person, you. Copyright law and enforcement does vary from country to country. That's why there are so many Turkish designer knockoffs. Ava is based in Luxembourg, and that would be a very crucial point if it weren't for the fact that Luxembourg is signed up to the previously mentioned Berne Convention. Ava can't have citizenship. It is not human. The rules still apply. And that is exactly what ultimately makes this situation so bloody vexing. I'm being copyright claimed for using a work of art that was made by something that legally cannot hold copyright. It's the monkey selfie all over again. Ava is a non-human. It's in its damn name. It cannot own copyright, and if we assume that the company that coded it to be the equivalent of Slater handing a McCork a camera, neither can her programmers. If PETA had won their case, I wouldn't have a leg to stand. And don't even get me started on the plagiarism issues. Okay, you can get me started on them, but that's only because that was going to be the subject matter for this upload, and so I realised how stupid it was that I got claimed by an AI, so I just had to talk about it. Today's drinking game. Rewatch the video and take a sip every time I say the word copyright. Drink responsibly. So this begs the question, should I appeal the claim? I could be taking a massive risk here. If I appealed this claim and it got rejected, my video could be taken down and my channel would get a copyright strike. The problem with appealing a copyright claim is that it can become legal, and I don't have the resources to deal with that. I'm not technically losing anything out from this copyright claim, but that's not the point. Were YouTube my full-time job and were I still a comparatively small creator, I wouldn't necessarily have the legal resources to be able to argue this should they deny my appeal. I could get a copyright strike and that could seriously affect me. I think the claim would be rescinded since my video comes under fair use, but there's still no certainty as it can vary on a case-by-case basis. This video is not about whether or not I should appeal this claim, but I just had to bring to your attention the idea that AI is claiming other people's videos, and this could set a perplexing, painful and petrifying precedence that could very well be another nail in the coffin for musicians and composers as we know them.